When you think about capital, what comes to mind? Maybe soaring skyscrapers, sprawling factories, or just, big piles of money.
Yeah, things that feel solid, right?
Yeah.
Physical assets or financial holdings.
Exactly. But what if that familiar picture is missing something fundamental? What if the real power, the real essence of capital, isn't just economic, but something forged and shaped by, well, by law?
That's exactly the surprising core idea we're diving into today. Based on the material you've shared, this deep dive reveals that capital isn't a natural phenomenon or just a collection of things.
Okay.
It's a specific kind of asset, one that's been legally coded, or you could say fortified, to grant its owners special privileges and power. The sources describe this legal framework as the very cloth from which capital is cut.
Okay, the cloth from which capital is cut. That's a powerful image. So it's not just money or property, it's money and property, plus something extra added by the law.
Precisely.
And this deep dive draws heavily from what looks like a really insightful book, digging deep into this legal dimension of wealth.
Exactly. And our mission today is to unpack this code of capital. We want to understand what this legal coding actually does to assets, who are the architects of this code, how it operates across the globe, and critically, how this often invisible process fundamentally shapes wealth, inequality, and even society itself.
All right, let's get right to the heart of it then. This core idea is that capital isn't inherently physical or just raw finance. It's ordinary assets, things like land, ideas, or even debts that are given special powers because the law wraps them in privileges.
Yeah, it's like giving them a legal superpower suit, as you said.
A superpower suit, okay.
And this legal superpower suit bestows a couple of crucial attributes onto assets, distinguishing them from ordinary possessions. The sources really highlight two main ones: durability and convertibility.
Durability makes sense. Legal coding seems designed to make these assets, or maybe pools of assets, last longer, protecting them from various threats, right? Especially from people trying to make claims against them, like creditors.
Exactly. Think about a family wanting to keep land across generations. Back in medieval England, landowners used these early legal structures, kind of predecessors to modern trusts.
Right.
Specifically to shield their land wealth from personal debts or claims against individual family members. The land itself might seem durable, sure, but its status has protected long-term family wealth. That was thanks to legal coding.
Huh.
Or think about a corporation. It's a legal person, right, with an indefinite life, totally distinct from its human owners, which allows it to accumulate and hold assets far beyond a single lifetime, legally shielded from the personal ups and downs of its shareholders. It enhances that durability aspect significantly.
And convertibility. That sounds like, well, being able to turn the asset into cash.
Specifically into state money. That's the key distinction.
State money. Why is that so important?
Because state money is unique. It's, at least nominally, guaranteed by the state's ultimate authority. Think its power to tax or enforce payments. Unlike private forms of value or money, state money has that unique backing.
So legal coding gives you the ability to reliably convert your coded asset into that state-backed money. Is that the idea?
Yes. It provides a reliable pathway to lock in gains or access liquidity. It gives state money a unique status over private forms. It means you can exit your position in an asset, relying on the state's power to ensure the conversion happens smoothly.
And crucially, none of this legal coding works unless a state, or maybe multiple states, are willing to actually back it up. If the law isn't enforced, the coding is just words on paper.
Precisely. The power of this legal code comes directly from the state's willingness to use its coercive, its courts, its enforcement mechanisms to uphold these legal privileges.
Right.
The sources give a really poignant example of Maya communities in Belize. They actually won court cases protecting their communal land based on property rights.
Oh, wow.
But their own government just ignored the rulings. So the legal victory was ultimately powerless in terms of creating durable wealth or security for them. It shows the absolute necessity of state enforcement.
It's fascinating that while the forms of capital we see, feudal land, industrial factories, complex financial instruments, tech startups have changed so much throughout history. The underlying legal building blocks, the source code, as the material puts it, have remained remarkably consistent.
They really have. Institutions like property law, contract law, trust law, corporate law, bankruptcy law. These aren't new inventions. They've evolved over centuries, of course. But they are the enduring foundation upon which modern capital is built, regardless of the specific asset class.
So if law is the code, who are the master programmers? The sources really seem to point the finger at lawyers. They're described as the true masters of the code of capital.
They are the essential technicians, absolutely.
Mm.
Lawyers are the ones who understand how to take these fundamental legal building blocks, the rules of property, contract, corporate form, and so on, and apply them to assets in specific, often really complex ways.
So they're grafting the code onto ordinary assets, turning them into capital.
That's a good way to put it. They figure out how to structure deals and ownership within the existing legal framework to achieve their clients' goals, maximizing durability, convertibility, protection.
And where does this coding work actually happen? Is it happening out in the open, in Parliament or Congress?
Increasingly, no. The sources really emphasize that much of this critical coding work happens outside the public gaze, largely within private law firms.
Ah.
It's described as being immunized from the public eye.
That makes a lot of sense. I mean, it's not exactly headline news how a specific trust is structured or how a corporate subsidiary is set up in some offshore jurisdiction.
Right.
And I guess this leads to the point about access then. The best legal coders, the ones who can implement the most effective cutting-edge legal strategies, they're going to be expensive.
Exactly. The market for legal services inevitably means that only the highest paying clients get access to the most skilled coders. And this isn't a neutral process, right?
Yes.
It directly influences which assets get the benefit of being coded as capital, and therefore who benefits most from the entire system.
How do the sources portray the lawyers themselves in this? Do they see themselves as, architects of inequality or just doing their job?
The sources suggest lawyers typically see themselves as serving their clients' business objectives and, importantly, operating entirely within the bounds of the law. They might even, perhaps a bit optimistically, hope for some kind of invisible hand to manage any broader economic or social effects of their work.
But you said earlier that their work actually shapes the outcomes. They're not just neutral technicians.
Yes, the point the source strongly makes is that because they are so effectively enhancing the power and privilege of certain assets through this legal coding, they're actively producing specific economic outcomes, like skewed wealth distributions. Their very success in coding capital has, in a sense, turned the idea of a naturally self-correcting invisible hand into, well, the source calls it a fairy tale.
Wow, okay. And this code, it isn't stuck within national borders anymore, is it? The sources talk about the code becoming portable.
This is a critical modern development.
Yeah.
Absolutely. Entrepreneurs and asset holders can now effectively select legal systems from different countries, often regardless of where the physical assets or the main business activities are actually located.
So they can pick and choose, like choosing a jurisdiction for its specific contract law.
Exactly. Or where to incorporate a company to get favorable tax rates, or maybe lighter regulations or stronger shareholder protections.
So you don't actually need to be in Delaware or the UK or the Cayman Islands to use their legal code. A paper or digital trail can be enough.
Pretty much, yeah. As long as there's some state, somewhere, willing to legally recognize and enforce the code you've chosen to use. This ability to shop for law is a major factor in how global capital operates today.
And this explains the dominance of specific legal systems then, like English law and New York law, particularly in finance.
It does. They have legal rules, particularly around what's called conflict of laws, basically, which country's law applies when there's a dispute involving multiple jurisdictions
Okay.
that are very permissive. They allow private parties a lot of freedom to choose the governing law for their contracts and assets, even really complex financial ones. The primer rule for financial assets is a key example mentioned.
Interesting. Let's maybe make this more concrete. Can we look at some specific historical examples from the sources? See how this legal coding has played out with different kinds of assets?
Absolutely. Let's start with coding land. That feels like the most ancient form of capital we might recognize.
Yeah, seems fundamental.
It is. And as we touched on earlier, back in medieval England, legal techniques like the use, and later the trust, were developed by lawyers. These weren't just about managing land. They were sophisticated legal shields.
Shields for what?
Designed specifically to make family land holdings more durable by protecting them from the debts and obligations of whoever currently held the title.
So the land itself was there, physically, but the trust gave it that extra layer of legal protection, making it capital that could endure across generations, sort of avoiding the shocks of individual owners' misfortunes.
Precisely. It fortified the asset stream for the dynastic family. However, the sources do point out that reforms later on, like in 1881, started stripping land of some of these unique legal fortifications, making it behave more like a standard commodity that could be more easily bought, sold, or seized for debt.
And in the Americas, obviously, settlers applied their own legal coding, didn't they? Claiming absolute property rights to land, which often completely disregarded the existing use rights of indigenous peoples.
Yes, a brutal example of legal coding establishing dominance. And while the U.S. initially had perhaps a more egalitarian distribution of land compared to Europe, it quickly adopted similar English legal coding techniques for wealth protection.
Like using trusts again.
Exactly. Using trusts and other structures for dynastic wealth preservation became common. And the sources bring up that tragic example of the Maya, again, even winning a legal claim based on property rights is useless if the state won't enforce it. Shows the fragility without state backing.
Right. And the enclosure movement's first of land, legally converting communal land rights into private property. And then what the sources call the second enclosure movement of knowledge through intellectual property. Those are powerful examples of how law actively reshapes who controls what assets, aren't they?
Absolutely. Shifting gears a bit, the sources talk about cloning legal persons, which is basically the creation and evolution of the corporate form.
The corporation.
Corporate law is really a masterclass in legal coding for durability.
How so? What specific legal powers does the corporate form confer?
Well, several key ones. The corporate entity provides what's called entity shielding. It fundamentally separates the assets of the corporation from the personal assets of its owners, the shareholders.
Okay, that's huge.
It is. It also allows for loss shifting, limiting the liability of those shareholders, often to just their initial investment, and sometimes shifting risks onto creditors or even, in some cases, the public through bailouts.
Right.
And crucially, corporations have legal immortality. They exist independently of their owners and can, in theory, continue indefinitely, accumulating and holding wealth across generations of shareholders.
So the corporate form takes ordinary business assets and legally transforms them, gives them durability, protection, and the ability to exist potentially forever, distinct from any individual person.
Yes. And the sources argue this powerful legal form has increasingly been used less for, say, physically producing goods and services, and more as a kind of virtual capital mint.
A virtual capital mint.
Meaning a legal structure primarily designed for generating and managing financial gain rather than just facilitating production.
The Lehman Brothers collapse sounds like a really stark example of how complex these corporate structures, layered with legal coding, can create massive systemic risks.
It is a key example discussed. Lehman had over 200 subsidiaries scattered across various jurisdictions like Delaware, the UK, Cayman Islands, plus hundreds of these special purpose vehicles, or SPVs.
Wow.
Each was a separate legal entity, technically shielded, but they were all interconnected financially, largely through debt that was guaranteed by the parent company. So while the legal coding provided entity shielding for each individual piece, the economic reality was this incredibly complex web tied together by financial guarantees.
And when the parent company failed, those legal shields couldn't stop the economic collapse cascading through the subsidiaries because the guarantees vanished.
Exactly.
Yeah.
It showed how these legally distinct entities were fundamentally economically bound. It highlights how the corporate form, designed to shield assets, can also be leveraged in ways that concentrate and then transmit systemic risk across an entire organization, or even, as we saw, the wider financial system.
And this ties back to that portability idea. Companies literally shopped for the best corporate law jurisdictions, didn't they?
Right. There was a major shift away from needing to incorporate where your actual business happens, the old real seat theory, to being able to incorporate almost anywhere, the incorporation theory.
Which led firms to places like Delaware.
Precisely. Because jurisdictions like Delaware offered corporate law seen as highly favorable, particularly in prioritizing shareholder interests and management flexibility.
The sources also mention some historical parallels here, like asset partitioning way back in 14th century Florence.
Yeah, using partnership structures, which spurred a credit boom back then. It shows that using legal structures to manage risk and reward, specifically allowing some parties, like shareholders or partners, limited liability, isn't entirely new.
So enabling high leverage for potential gain while pushing potential losses onto others, that has deep roots.
It seems so. And the sources connect this historical pattern to modern bailouts, showing how that loss-shifting function of corporate coding can ultimately extend to the public purse when large, interconnected financial institutions built with complex legal coding face failure.
Okay, let's move to the next asset type, minting debt. How is plain old debt legally coded into capital?
Well, the sources argue that debt becomes a really defining form of capital in capitalism when it is made easily transferable and reliably convertible into state money.
So it's not just about owing someone money, it's about owing someone money in a way that the right to collect that money can be easily bought and sold by others and eventually turned into official cash.
Exactly that. Early forms, like simple promissory notes, I owe you X amount, became transferable through legal innovation, starting around the 12th century. This often involves some pretty creative workarounds,
Like what?
like initially making the note payable to a messenger or bearer to get around older legal rules that made it difficult to directly transfer an obligation owed to a specific person. Little legal hacks, essentially.
Huh, okay. And then came bills of exchange. They were a step up.
Yes. Bills of exchange took transferability much further. They became highly liquid instruments, partly because their legal coding limited the kinds of defenses a debtor could raise against someone who later acquired the bill in good faith.
Oh, making them safer to accept from strangers.
Exactly. And while they're sometimes romanticized as emerging purely from some stateless law merchant, the sources strongly emphasize that their widespread use and effectiveness absolutely depended on the legal support and, crucially, the enforcement power of city governments and state courts. They needed that state backing.
Okay, so that's historical debt. What about something more modern like securitization, turning, say, thousands of mortgage payments into tradable assets? How does that work legally?
Securitization is a prime example of sophisticated modern legal coding. It's the legal process of taking future income streams, like the monthly payments on a huge pool of mortgages, and using specific legal structures, very often trusts or SPVs.
Those STVs again.
Yep, those special purpose vehicles. Using them to transform those anticipated future cash flows into immediately tradable financial assets, like residential mortgage-backed securities, RMBS, or collateralized debt obligations, CDOs.
The sources give this really specific complex name as an example. The Citigroup Mortgage Loan Trust 2006 New Century 2. What does a name like that actually tell us about the legal structure?
It tells you quite a bit, actually. It highlights the structure used likely in New York Trust, hence the year 2006 and maybe NC2 indicating a series.
Yeah.
It holds mortgages originated by a specific lender, New Century, which was a major subprime lender, and it was sponsored or put together by a large financial institution, Citigroup.
Okay.
Investors bought interests, basically shares, in this trust, which legally owned the pool of mortgages. And they often relied heavily on credit ratings assigned to those shares, rather than digging through the hundreds of pages of dense legal details in the prospectuses themselves.
And the rating agencies, they provided ratings that, well, turned out to be wildly inaccurate in many cases before 2008. Did they face much legal responsibility?
Largely, no. They were quite successful, particularly in U.S. courts, in arguing that their ratings were merely opinions, and therefore protected as free speech under the First Amendment.
Just an opinion, even though investors relied on them.
That was the prevailing legal argument that succeeded. Although, the sources note, some courts have started to push back a little, maybe differentiating between widely distributed ratings and those given privately, suggesting the latter might be closer to commercial speech with less protection. But generally, they had strong legal defenses.
There's also mention of the Ibanez foreclosure case in Massachusetts. Sounds like that exposed some legal sloppiness in the securitization chain.
It really did.
Yeah.
Mr. Ibanez defaulted on his mortgage, and the bank trying to foreclose simply couldn't produce the proper legal paperwork proving it actually owned the mortgage.
Why not?
Because the mortgage note had supposedly been transferred multiple times through various entities, often these SPVs set up by firms like Lehman, as part of the securitization process. But the documentation showing that clear chain of ownership was missing or improperly handled.
So the court said, show me the proof.
Exactly. The Massachusetts Supreme Judicial Court demanded proper proof of ownership and the legal right to foreclose, highlighting the potential legal chaos underpinning the whole mass securitization process, where paperwork perhaps didn't keep up with the speed of the deals.
And MERS, the Mortgage Electronic Registration Systems. Was that an attempt to fix this paperwork problem?
It was an attempt to streamline it, maybe bypass some of it. MERS was an industry-created entity, basically a database, intended as a shortcut. Mortgages were often registered in MERS's name as a nominee or agent, even when the underlying loan was sold multiple times between institutions.
To avoid recording every single transfer.
Exactly. to avoid the cost and hassle of recording every assignment in local county land registries. But courts later questioned the legal validity of MRSA's standing to actually initiate foreclosures, for instance, showing that these kinds of industry-wide legal shortcuts can face serious legal challenges when tested.
Okay, and then CDOs, like one called Claro C. That sounds even more complicated. What were they doing legally?
CDOs like Claro C were another layer of legal structuring. They were often legal entities designed specifically to buy up the riskier slices, the mezzanine tranches of other asset-backed securities like RMBS, the bits that maybe fewer investors wanted to buy directly.
So they buy the risky stuff.
They buy the risky stuff, pool it together in this new legal entity, the CDO, and then using complex financial models often based on, frankly, questionable assumptions about how likely different loans were to default at the same time. They legally sliced up the ownership of that pool into new tranches. Through this process, they could often get the senior tranches of the CDO itself rated AAA by the rating agencies.
Wow, so turning unwanted risk into AAA-rated assets through legal and financial engineering.
Essentially, yes. It made those senior tranches attracted to a much wider range of investors, like insurance companies or pension funds, who might have rules saying they can only buy highly rated assets. It was about using legal coding to transform perceived risk and create entirely new classes of financial assets.
The sources draw parallels here too, don't they? To historical examples like Credit Mobilier in 19th century France.
They do. Karl Marx, interestingly, wrote about Credit Mobilier back in 1856. He saw it as this highly leveraged structure, issuing bonds backed by shares in other companies. He argued it was inherently unstable because its structure essentially bound its creditors to the risks of its underlying investments, but without the potential upside of profits if things went well.
And he predicted it would fail.
He predicted it would require state intervention to survive, which it eventually did. The sources see this pattern: highly leveraged financial structures created through legal coding, which concentrate risk and ultimately require bailouts, echoed in more recent crises.
And the hedge fund LTCM back in 1998 is another example mentioned.
Right. Long-term capital management. Another case of a highly leveraged entity using complex financial strategies that ran into trouble. In that case, a consortium of major banks had to step in and effectively convert their debt claims into equity to prevent a wider market collapse. Again, highlights how legal structures layered with debt create specific, sometimes systemic risk profiles that can unravel quickly.
Okay, so we've covered land, corporations, debt. The last big category seems to be about intangibles, enclosing nature's code and things like ideas.
Yes. The sources argue that today, capital is increasingly seen perhaps less as a tangible thing and more as a quality.
The quality.
The legal ability to capture and monetize predictable future returns. And intangible assets, think patents, copyrights, trademarks, branding, data, are absolutely central to this modern form of capital.
So capital is now significantly about legally capturing future income streams from knowledge or ideas or even biological processes, not just from physical stuff like factories.
Precisely. Intellectual property, IP rights, are a very clear form of legal coding applied to these intangibles. A patent, for example, isn't the invention itself. It's a legal right granted by the state to exclude others from making, using, or selling that invention for a set period.
Which allows the holder to monetize it.
Exactly. It creates a legal monopoly, albeit temporary, to facilitate commercialization and capture returns.
And the sources mention the history of patents wasn't always just about protecting lone inventors, right?
No, definitely not. Early patent-like systems, like those in Renaissance Venice or Tudor England, were often used explicitly as tools of industrial policy.
How so?
By granting temporary monopolies to attract skilled workers from other regions, or to encourage the development of specific domestic industries deemed important by the state.
And fast forward to more modern times, U.S. industry has really pushed for stronger global IP rights.
Yes, very actively. Lobbying the U.S. government to use trade negotiations and sometimes threats of sanctions to pressure other countries into adopting strong U.S.-style IP protections.
Are there examples?
The sources mention pressure on Brazil, and also the negotiations during NAFTA with Mexico, where U.S. industry representatives were apparently quite pleased that they got all we wanted regarding IP protections written into the agreement. And perhaps one of the most striking examples of coding nature's own processes is the case of Myriad Genetics.
Ah, the breast cancer genes, BRCA1 and BRCA2.
Exactly. They obtained patents on the isolated genes themselves, and they enforced them, sending cease and desist letters to university labs and hospitals that were offering genetic testing for breast cancer risk based on those genes.
Which led to a big legal challenge.
It did. It went all the way to the U.S. Supreme Court, fundamentally questioning whether human genes, even when isolated, could be patented at all. It really pushed the boundaries of what the law would allow to be enclosed and privatized as intellectual property.
And what about algorithms, like Google's PageRank algorithm being patented?
Yes, the sources described this as a form of legal engineering, applying patent law, which traditionally covered physical inventions, to something intangible, like a mathematical algorithm. Essentially patenting a specific method or a digital filing system based on its functional expression and utility. It shows how legal coding constantly adapts to capture new forms of value creation.
So whether we're talking about land, corporations, debt, or intellectual property, the underlying process seems remarkably consistent, doesn't it?
It does.
It's about using these core modules of property law, contract law, corporate law, trust law, IP law to give certain assets special rights, to enhance their durability as capital, protect them from competing claims, and facilitate their conversion into state money. It really sounds like this is the fundamental process defining what capital is, according to these sources.
That's the core argument. The sources contrast this view with those who might point solely to the rise of intangible assets as the defining feature of modern capitalism.
Saying what?
Saying that even traditional tangible capital, like factories or land, always relied on this same underlying legal coding process to function as capital. The shift isn't just about what the asset is, tangible versus intangible, but about the kind of legal privileges it carries, which are created through this coding.
And this legal coding, as we discussed, doesn't stop at national borders. The sources talk about a kind of global legal empire. How does that work?
It's interesting. This global system isn't built on every country adopting the exact same laws. That kind of harmonization is rare. Instead, it relies heavily on states agreeing to mutually recognize and enforce foreign law. Particularly when private parties in their contracts or corporate structures have chosen which country's law should govern their arrangements.
So this mutual recognition and enforcement of other countries' laws is what really enables global finance and commerce on the scale we see it.
Exactly. It's how a structure like Lehman Brothers could have subsidiaries legally incorporated in multiple jurisdictions, yet operate as a somewhat integrated global entity. It's how financial assets can be coded using the laws of one country, say Delaware corporate law or English contract law, or maybe trust law from the Cayman Islands, but still be bought, sold, and recognized as valid claims globally.
But surely this creates tensions with national sovereignty, countries having their own laws potentially challenged or bypassed.
It absolutely does. And investor-state dispute settlement, or ISDS tribunals, are a prime example of this tension brought into sharp focus.
Right, ISDS. That's where foreign investors can sue governments directly.
Yes. Typically under provisions in international trade or investment treaties. They can bypass the country's own domestic court system and take the state directly to international arbitration.
The Eli Lilly versus Canada case sounds like a significant example mentioned in the sources. What happened there?
It is significant. Eli Lilly, a U.S. pharmaceutical company, used an ISDS tribunal under NAFTA to challenge a decision made by a Canadian court regarding the validity of one of its drug patents.
Challenging a domestic court decision in an international tribunal?
Precisely. And the sources highlight something particularly interesting about the arguments used. The tribunal allowed expert testimony that essentially compared the Canadian court's rulings and reasoning to how courts in other countries, like the U.S. and Mexico, might have ruled on similar patent issues.
Implying what?
Implying, critics argued, that the Canadian court's decision was somehow unfair or deviated from an expected international standard simply because it differed from potential outcomes elsewhere, particularly outcomes potentially more favorable to the investor.
So an international arbitration panel was effectively second-guessing a sovereign state's own judicial process based on perceived investor interests, using expert opinions about how courts should ideally rule from a certain perspective.
That's certainly the concern raised by critics and highlighted in the sources. These arbitrators often have very broad powers of interpretation, and their decisions aren't typically subject to the same kind of rigorous appeal process as domestic court rulings. It raises profound questions about sovereignty, democratic accountability, and whether these systems unduly favor investor rights over public policy concerns.
And the debate over ISDS was a major sticking point in trade negotiations, like the proposed TTAP between the U.S. and Europe.
A huge sticking point, yes. Concerns about ISDS potentially undermining environmental regulations, health standards, or other public interest policies were central to the opposition against TTAP.
Okay, so states allow this generally, but where do they tend to push back hardest against this global legal code? Bankruptcy seems like a sensitive area mentioned.
Bankruptcy is definitely a key sticking point. States are generally very reluctant to completely cede control over the process of winding up failed entities within their borders, deciding who gets paid what when a company collapses. It's seen as a core sovereign function.
But even there, exceptions exist, pushed by private actors.
Yes. Even in bankruptcy, powerful private organizations have successfully lobbied for significant exceptions to standard national rules. The International Swaps and Derivatives Association, ISDA, is a prime example.
What did ISDA lobby for?
They lobbied successfully in dozens of countries for special safe harbors in bankruptcy law, specifically for derivatives contracts and repurchase agreements, or repos.
Safe harbors, what did those do practically?
They essentially exempted these specific complex financial assets from the standard rules that would typically kick in during a bankruptcy, rules like the automatic stay, which freezes assets, and the principle of distributing remaining assets equally among creditors, pari passu.
So holders of derivatives and repos got preferential treatment.
Exactly. The safe harbors allowed them to terminate contracts, seize collateral, and net out positions outside the normal, orderly bankruptcy process, even if other creditors had to wait or got less back. It gave them a significant advantage.
And what happened if parts of the financial industry didn't want to adopt certain standards related to this, like agreeing not to immediately seize collateral during a crisis?
That's another interesting dynamic. After the 2008 crisis, there was a push for firms to adopt ISDA's standard protocol for resolution stays, basically, agreeing contractually not to exercise those safe harbor rights immediately if a major counterparty failed, to give regulators time to step in.
But some resisted.
Some hedge funds, reportedly, resisted signing up, and then regulators, like the U.S. Federal Reserve, effectively stepped in. They issued rules that essentially prohibited regulated banks from trading derivatives with firms that hadn't signed up to the ISDA protocol.
Wow, so compelling compliance through regulatory pressure.
Yes, it shows this complex interplay. Private bodies like ISDA coding rules through standard contracts and lobbying, and then sometimes state regulators using their own coercive power to enforce the adoption of those privately created rules across the market. So let's try to pull this all together. The central argument we've been unpacking is that capital rules by law. Not necessarily through, mustache-twirling villains directly capturing the state, but through this more pervasive, decentralized, and often incremental legal coding process. A process carried out mostly by private parties' asset holders, yes, but critically, their lawyers acting as the technicians.
And it sounds like this process isn't neutral in its effects at all.
It's inherently not neutral. By its very nature, this legal coding process privileges certain types of assets and certain ways of holding them. It inevitably leads to a structural bias in the economic system, favoring some asset holders over others.
And the sources argue this bias contributes significantly to the rising inequality we see across the globe.
Yes, they draw a direct line. They see rising inequality not just as an unfortunate market outcome, but as a direct consequence of a system that systematically uses legal coding to fortify the claims and enhance the privileges of certain assets and their owners, while often leaving other types of assets or claims, like labor or communal resources, less protected.
And ironically, that very inequality is seen as perhaps the greatest threat to capital itself.
That's the argument presented, because capital's power ultimately relies on the state's willingness to enforce the legal code.
Right, the state backing we talked about.
Rising inequality, if perceived as fundamentally unfair or illegitimate, can erode public trust in the state and its legal system. And that erosion of legitimacy potentially undermines the very foundation upon which capital's power rests.
This incremental pushing of legal boundaries you mentioned earlier, like patents on genes or creating those derivative safe harbors, it sounds like the legal code is constantly being tested and expanded in private practice before public bodies or courts fully catch up or react.
Exactly. These key modules of the code, the trust, the corporate form, the derivative, new forms of IP, they often evolve through private creativity and lobbying. They get used, refined, and gain traction in private transactions and legal structures, sometimes for years or decades, before courts or legislatures fully grapple with their broader implications or attempt to regulate them comprehensively.
And challenging this system once these structures are in place sounds incredibly difficult.
It is presented as very difficult. The sources highlight the significant hurdles, the sheer cost of complex litigation, restrictive legal doctrines like standing, proving you have the right kind of direct injury to even bring a case, statutes of limitation, cutting off claims after a certain time, and of course, successful lobbying by powerful interests against tools that could potentially challenge their coding strategies more easily, like robust class action lawsuits.
It creates a kind of first mover advantage for those coding capital.
A significant one, yes.
Yeah.
For those using legal coding to fortify their assets and claims.
So the overall outcome seems to be a legal system that becomes heavily focused on protecting and enhancing private property rights, sometimes without adequately considering the spillover effects, the externalities on others, or the impact on broader social goals.
Leading to what the sources starkly call radically different positions of power within society. Inequality from this perspective isn't just an unfortunate byproduct of markets. It's presented as a logical, almost inevitable result of a legal system that systematically privileges certain assets and claims over others, especially in a globalized world where capital can credibly threaten to exit a jurisdiction if the legal environment isn't deemed favorable enough.
Okay, so we've spent a lot of time on the legal code. What about the new kid on the block? The digital code. Things like smart contracts, cryptocurrencies, blockchain, are they a potential challenger to this legal empire?
That's a fascinating question the sources explore right at the end. They definitely pose the question, can this new digital code truly operate independently? Or will it ultimately need to rely on the existing legal code for protection or enforcement? Or perhaps will it simply be constrained or even co-opted by the masters of the traditional legal code?
Part of the promise or hype around smart contracts is that they're self-executing, maybe even immutable, meaning they can't be changed once deployed. Does that fundamentally challenge the flexibility, the malleability of legal code?
The sources express some skepticism about true immutability in practice. They argue that digital code isn't magically immune to bugs or errors. It can be incomplete, unable to handle unforeseen circumstances that legal contracts often account for with ambiguity or processes for adaptation. Digital code often relies on external data, feeds oracles to interact with the real world, and those oracles can be fallible or manipulated. And crucially, humans still want the ability to renegotiate or fix things when stuff goes wrong, just like they do with legal contracts.
The desire for an undo button.
Exactly. The legal code is inherently malleable. It allows for interpretation, renegotiation, amendments, judicial discretion. For digital code to truly compete or replace it in many complex situations, it likely needs mechanisms to adapt and change, which inherently introduces complexity and potential points of human intervention, undermining pure immutability.
The DAO example seems to illustrate this point perfectly, doesn't it?
It's come the classic case study, yes. The DAO, Decentralized Autonomous Organization, was meant to be this revolutionary investment fund running purely on its digital code, governed by immutable smart contracts on the Ethereum blockchain.
But it got hacked.
Well, technically, a loophole or unforeseen consequence in the code was exploited, allowing someone to start draining millions of dollars worth of cryptocurrency out of it, following the rules of the code as written.
So the code worked, but not as intended.
Precisely. And the community faced a crisis. Do they stick to the principle of code is law and let the funds go? Or do they intervene? Ultimately, the majority chose to intervene. They performed a hard fork of the Ethereum blockchain, essentially, rewriting the transaction history to override the supposedly immutable code and return the funds.
So even with immutable digital code, human decision-making and the desire for a different outcome, the pragmatists, as the source calls them, ultimately won out.
Exactly. It was a powerful demonstration that code is, in practice, malleable when the human actors involved collectively decide it needs to be. Human discretion, social consensus, and collective decision-making remain incredibly powerful forces, perhaps ultimately more powerful than the code itself in the long run.
Is there a risk, then, that digital coding could just end up replicating the same biases we see in the legal system?
That's a very real concern raised in the material. Just as formalizing land rights through Western property law, historically privileged individual private ownership, and often displaced communal or customary claims,
Right.
Formalizing claims solely through digital code could potentially sideline or disadvantage collective rights, informal economies, or groups who lack the technical expertise or resources to participate effectively in these new digital coding infrastructures. It could be another form of enclosure.
Bitcoin feels like it embodies this whole tension, doesn't it? The crypto-anarchist dream of a stateless currency versus the deep fears of regulators and law enforcement.
It absolutely does. For some, it represents the hope for a financial system entirely outside state control, free from censorship or manipulation. For established states and law enforcement, it represents a potential loss of visibility and control over money flows, raising concerns about tax evasion, illicit finance, and monetary policy impotence.
And the source's final lesson, drawing from the history of the legal code, seems particularly relevant here. What was it?
Pay close attention to the relationship that develops between the innovators of the new code, the lead digital coders, the architects of these new systems, and the established power players, the resourceful legacy investors and institutions.
Why?
Because the history of the legal code suggests that the most powerful actors tend to find ways to adapt new legal technologies and coding strategies to serve familiar interests, protecting wealth, managing risk, gaining advantage. It remains to be seen how that dynamic plays out fully with digital code, but history offers a cautionary tale.
So, stepping back from the digital challenge for a moment, what are the main critiques leveled against this whole system based on the legal coding of capital?
The primary critique that comes through is that this system, by intensely prioritizing the fortification of private rights and claims through legal coding, can sideline processes of collective self-governance. It tends to depoliticize vast areas of economic life.
Depoliticize.
Meaning it moves crucial decisions about how wealth is generated, protected, and distributed out of the realm of public debate and democratic decision-making, and into the more opaque world of private legal offices, complex contracts, and specialized court rulings.
And what about alternatives or ideas for change mentioned in the sources?
The sources briefly touch on a couple of ideas. One is the radical markets proposal, which suggests using market mechanisms themselves, like novel auction systems for property or quadratic voting, combined with significant redistribution to try and break up concentrations of power. Though the sources seem to imply this might be quite extreme or perhaps utopian.
What's the other idea?
A more fundamental idea, which aligns closely with the core thesis of the deep dive, is the need to consciously repoliticize economic life.
Repoliticize? How would you do that?
Essentially, by challenging the often unspoken assumption that economic rights, like property rights, were somehow based on abstract, natural, or extra-legal principles. Instead, the call is to recognize explicitly that these rights are actively selected, designed, and fortified by humans using the tool of law.
So accepting that law creates these rights.
Yes. And if law is our primary tool for democratic self-governance, then its use in creating and distributing capital needs to be brought back into the public sphere for collective deliberation, debate, and conscious political control, rather than being seen as a purely technical or private matter. So just to sum up our deep dive today, capital isn't just money or physical things. The sources argue it's fundamentally a legal creation.
Right.
It's ordinary assets that get endowed with special privileges. Durability, convertibility, protection through a process of legal coding carried out by skilled professionals, primarily lawyers, operating within specific legal traditions.
And this legal code is portable, operating globally through a system of mutual recognition, often prioritizing private choices made in contracts and corporate charters. Exactly. And this entire process, by its design, has a built-in bias, favoring certain assets and owners, which the sources argue contributes significantly to the patterns of inequality we see today.
And while new technologies like digital code are emerging as potential challengers or alternatives, their ultimate relationship with the established legal code and the powerful interests that shape it is still very much unfolding.
Understanding this legal coding process, this code of capital, is presented as absolutely essential for understanding how wealth is really created, concentrated, and distributed in the modern world. It reveals just how deeply the dynamics of capitalism are intertwined with and actively shaped by the specific design of our legal institutions.
So here's a final thought to leave you, our listener, with. Given that law is supposed to be our primary tool for democratic self-governance, how we collectively decide how our society works, what does it mean for our ability to shape our collective future when the very code that determines who has wealth and power is so often crafted, refined, and reinforced in private law offices, shielded from direct public view, and maybe even democratic debate?
It's a powerful question to sit with, isn't it? What are the real implications when the fundamental rules of the economic game are written not just in legislatures and public forums, but perhaps just as importantly, in the quiet, incremental, and highly specialized work of legal coding that happens largely away from public scrutiny?